Ladies and gentlemen, we've got a positive cornucopia of talent here for you. Well, almost here, because I've got Rupert Cowper-Coles from RPC, a media partner there. I've got Eliot Higgins, the founder of Bellingcat. And we've almost got Carole Cadwalladr, who is a just-in-time delivery, and you'll see her sneak onto the stage in but a moment. And I have sad news for you all. Unfortunately, Caroline Muscat was rammed on her way to the airport at Lucca Airport in Malta last night. And last I heard, she's in hospital. I hope she's okay. But she, unfortunately, will not be able to join us today. And, of course, we send our best wishes for her speedy recovery. I have to say I felt somewhat guilty that I assumed, being Malta, it was deliberate. I'm glad somebody else in the room thought that. I felt a bit guilty about it, but maybe it was the right thing to be thinking. I don't know. Anyway, it's been absolutely fabulous watching today unfold and seeing this sort of growing recognition that SLAPPs are a problem and a problem that we can find answers to. And then you sort of feel that you've made all that progress, and then you hear a regressive voice that doesn't really believe that SLAPPs exist yet. And that's always a bit of a disappointment, but it's an opportunity, it's an advocacy inflection. And I think one of the things that's really important about this is that lawyers are obviously not often the best policymakers. Particularly, Eliot, I think they don't understand the personal story that goes with it. So just talk to us, because one of the things we want to talk about here was the personal experience of SLAPPs, both in terms of emotional, financial, and everything else. So you want to tell us a bit about the impact on you?
Sure. So my experience started in December 2021, just before Christmas. I got a letter from Discreet Law, who were representing Yevgeny Prigozhin, who we now know...
Have they done their money laundering checks?
Well, this is all part of the story. So at the time, he was sanctioned in the UK and European Union and US because of his connections to Wagner, the mercenary organization, something he had denied. He had sued people in Russia for that. And I received this letter, and it explained that I was being sued for libel because of several tweets I had made several months earlier that linked to articles, two Bellingcat articles, which is published by my organization, one from Spiegel and CNN that spoke about his connections to Wagner. I didn't even say in the tweet he was connected to Wagner. It was in the articles I tweeted. So apparently that was libelous. And I was caught by surprise by this because, rather annoyingly, they had actually sent another letter a few months earlier to my old office address, which I no longer use. And they said, if you don't respond in 2 weeks, we're going to take this action forwards. So, and this was a couple of weeks before Christmas. So rather than preparing for Christmas, I had to find a lawyer very quickly. I was able to get in touch with Hugh Joy & Partners. And we started looking at this. And it was really the most obvious SLAPP case you can possibly imagine. This was not him suing Bellingcat for the articles that were published. This was him suing me as a private individual for tweeting articles. That's something that's very important about this. What then unfolded over the following months were basically a series of revelations that came out of leaked emails that had been hacked of his lawyers in Russia. And in those emails, it actually contained communications between Discreet Law and his lawyers in Russia discussing the case. And within that, it became very clear that what had triggered this is that Bellingcat's work had been mentioned in the descriptions of EU sanctions against Prigozhin. And he was trying to fight back against those sanctions. It was part of an entire campaign that was being orchestrated. In the US, he was trying to target the BBC, but I was the kind of first target of this because he was trying to use me as a way to put pressure on me and also undermine that case. His lawyers had, in the UK had warned him it could be an abusive process because he wasn't suing Bellingcat in the Netherlands, he was suing it in the UK. It didn't matter because it was really about damaging me more than anything. he was also advised by his lawyers that he shouldn't make this public as soon as the letters were sent out to me, because that would also be seen as an abusive process. His lawyers were saying, in Russia, were saying he really, really wants to make this public. So it was very, very clear this was about attacking me, my reputation, and causing me as much harm as possible. What happened then?
Well, I mean, can I just, I mean, we'll get to that, I hope, but, and welcome, Carole. I've already introduced you, and we're going to hear your personal testimony in a minute. But just talk a bit about, 2 weeks before Christmas, almost a replica of today. What is the feeling that you have when someone like him with a bottomless pocket's coming for you?
And it was incredibly stressful. I at that point, I didn't have lawyers ready to call up and say, hey, I'm being sued. I do now, but that's because he sued me. He was the first person to do that. And I basically had a period. I mean, we'd come down. I had a lot going on in my personal life that was quite stressful, and then this all was dumped on top of me. And it was really, really difficult. I mean, the first week was incredibly stressful. I had sleepless nights. I was really worried that, where would the money come from this? I'd seen, obviously, from Carole's case, how much money this could cost. Fortunately, Bellingcat said they would cover all the legal costs, because it was obviously an attack on me to attack Bellingcat in our reporting. But even then...
I mean, that was lucky, because that's not obvious. It doesn't happen all the time.
Yeah, again, with Carole's case, unfortunately. Okay. So I was extremely worried. And also, the fact is, Bellingcat, at that point, our turnover was about 1.5 million a year as an organisation. And considering how high these costs can get, that would have been a significant part of our income. So the question was, do we crowdfund for this? If we're crowdfunding, does that mean we use donations elsewhere?
Before we get on to the crowdfunding bit, you keep dodging the question I'm looking for, which is about, the financial pressures on you. I mean, do you have a mortgage? Were they going to nick your home? What's going on here in the background? If you can share that.
I'm not like Mr. Moneybags.
I don't want to be, sort of prying through the net curtains, but I do actually.
I didn't have. I mean, we've got like savings in our family, but we didn't own our house. We were renting at that time. So had I have had to spend this money, it would have basically wiped out our savings immediately. I probably would have had to have gone bankrupt, because there would have been no way I could have paid hundreds and thousands of pounds of legal costs. As an organisation, even if Bellingcat covered those costs itself, I mean, our funders do not expect our, donations to be spent on legal fees, and that would also cause a huge problem for us. So we were, individually and also as an organisation, in a great deal of danger because of this action.
So it's turning out to be the existential threat to you and your organisation that he wants it to. It's the bullying.
Yeah, and at Bellingcat, we'd already started building a kind of war chest for this kind of thing, but it hadn't got to the point where we could defend ourselves against legal actions like that in the UK with that money. It was still quite a small amount of money. So, it was extremely unpleasant and stressful. I would not recommend it.
Carole, share your pain with us, if you will.
It's kind of interesting, because a year ago I spoke on this same stage, and the pain was very sort of present and apparent at that time. And I like to think that I've now finally been able to sort of move on and move past it. So I suppose listening to Eliot there is like it's
triggering you.
It's kind of like it's bringing back some of it. Tell me, Mark.
Well, I mean, one of the things that I think is challenging for people who perhaps don't recognise the existential threats. I mean, increasingly the judiciary are reluctant to recognise SLAPPs, whereas, SLAPPs are now being universally recognised. They're coming out in legislation in the EU. People are recognising there's a problem here, but there are still some parts of the legal profession which I think are reluctant, and there's still arguments. So at the International Bar Association, we've got a lot of American lawyers who think you should be able to do anything for money, including SLAPP people. And I think one of the pieces of this jigsaw that we're missing is the human impact, the human cost, the human toll. So, if you're at the BBC or The Guardian, or you've got good financial grounding behind you, then it's part of the job, and if you lose, that's unpleasant, but, it's not devastating to your life. And I think the purpose of the SLAPP is to make it an existential threat, isn't it?
And I think that's right. I mean, I think the fact is that even if you're a big news organisation, you're an editor at a big news organisation with resource and finances behind you, dealing with legal threats is really difficult and really stressful, and has ramifications on what you're able to do. If you're facing that as an individual, without that organisation behind you, without those resources behind you, without a detailed, granular knowledge of the law, and with what is absolutely an existential threat. I mean, I find one of the things I've always found about this is that people, they really latch on to the money and the threat and what it's going to do to you financially. And that's really helpful because I think people can relate to that. But for me personally, that it was so much bigger than that. It was existential because it wasn't just my financial future. It was my career. It was my reputation. It was my ability to earn a living. It was so bound up in that. And it absolutely did silence me. It silenced me for a long time. It continues to silence me. You know, I was a very active, quite loud voice through a lot of recent history. I am no longer on Twitter. That is directly related to this case. And what is one of the key things about these SLAPP cases and about what marks and characterises, in my view, an abusive case, is the way that it intersects with other forms of threats and intimidation and abuse. And in my case in particular, you know, there are probably people in this room who say, well, that wasn't really a SLAPP case. Didn't the judge say in the judgment that this isn't a SLAPP? And I think they are really missing a big part of the picture. Of the fact is that we are no longer in traditional journalistic waters, in that we print things in the newspaper and we defend those and X, Y, Z. We're operating in this hybrid landscape in which what happens online and the way that lawsuits feed into what happens online is absolutely a key part of this and is a key part of the threats against journalists at this time. And in my case is that I, first of all, turned into a figure of abuse publicly. I became this culture war hate figure. And it's that, I believe, that kind of created this sense of permission to go after me, to pick me out for these legal threats. A lot of other journalists wrote about Arron Banks. A lot of investigation was done. I was the only person who went after. He didn't go after The Guardian. He didn't go after Ted. He came after me personally. And in going after me personally, every single thing that happened in the legal case was then weaponized and used to beat me in this online sphere. But it had also silenced me and made it impossible for me to speak. So it had a profound effect that way. It had a profound effect on British public life because this man who has essentially paid for this significant events, this election, this referendum, which has changed Britain's constitution, has been free of any kind of journalistic or public scrutiny for the last 4 years. And his major ally now has also been free of that scrutiny, Nigel Farage, which was the campaign that he funded. He's now free to cavort across our television channels on a nightly basis as a lovable figure of fun. Sorry, that was a bit of a rant.
Hope you're voting for him to come out every night, remove his platform. But I think there's one other thing that I want to delve into, if you'll permit me.
Yes, that was rather. I went off.
No. It was actually quite informative. Well, very informative, highly informative. The thing that I'm interested in is that, you know, I think people just don't understand how you as journalists are defined by the work you do, how you're defined by the job and the obligation to tell the truth as you see it. And I just wonder whether there's something that we've missed about an attack on your personal identity. You talked about your credibility, but it's also something more than that, isn't it? Isn't it an attack on your identity as well?
Well, I mean,
maybe not.
In my case, I don't think I was anywhere near severely affected as you were, because Prigozhin was such a cartoonishly evil figure. He was sanctioned for the very thing he was suing me for, that it was almost an honour to be sued by him, really, more than anything.
Only in retrospect.
Yeah, I mean, at the time it wasn't very nice, but I mean, it's really the best money we've spent because of the impact it's had. I mean, we're still out of pocket, and it's going to be very difficult to assume where he is now, but we're still trying. But it was a reflection of just how much the UK legal system can be abused and used to target individuals, especially when the information that was contained in the emails were leaked came out and just detailed that that's exactly what they were doing. They knew what they were doing, and I was just being used as a way to, counter these sanctions against him.
Rupert, you're a lawyer, a partner at RPC. What's your observation about acting for people who are being attacked by SLAPP or lawfare and that kind of thing?
Well, yeah, it is something that does push the... we have our professional obligations to our clients, but when the Foreign Policy Centre first approached me about SLAPPs and libel reform about 3 years ago to talk about this issue, it was a bit of a cathartic moment, because when you take clients through this process, it is extraordinarily traumatic for them, and you're only carrying a very small part of that with you. But when your client is worried they're losing their house, spending their life savings, their pension, and all because they are refusing to be bullied, to take down an article, say sorry for something they know is true, you have enormous respect for your clients, and you feel an incredible responsibility to get the right result in a system where getting the right result. We've got fantastic judges, but there's an enormous cost to get there and an enormous litigation risk. It's very hard to know how the cards will actually play out at trial. I mean, we like you act for a lot of media organisations, and about a year into every case, you have something called a cost and case management conference, where parties now submit their budget, what they think it'll cost to take to trial. And it's been a long time. If I can't actually remember the last time I saw a claimant's cost budget for under £1 million. We had one a couple of years ago, which started off at £4 million just to get to trial, over 15 tweets, an allegation that had been made very, very widely, and you try and chip that down, but that adverse cost risk is what you're telling your client about when they get their first letter of claim. If they sue, and if they win, it's not the damages which will really hurt you. It's the costs which would ultimately flow from that.
Do you think that cost budgeting is being used as a kind of threat or an additional blackmail element in the case? Not in the traditional sense of blackmail, I mean in the colloquial sense, that you're putting the journalist in terrorem, aren't you? You're trying to scare the living shit out of them that they're going to be bankrupt.
I mean, there is a part of that, but I mean, it's a system which is designed to control costs, because costs were out of control. But take that £4 million cost budget we got the master to knock it down by some extraordinary figure to about half what they put in for.
Still going to bankrupt most reasonable people.
Still at £2 million, and so yeah, it's not a solution.
Do you think that this the latest trend, which I'm sure you two applaud, of lawyers being hit with lawfare claims and SLAPP claims, do you think this is going to be a spur to reform of SLAPPs? Do you think that more lawyers are likely to recognise a SLAPP when they see one, if lawyers are on the wrong end of them?
So lawyers being threatened themselves? Yeah,
it happens less here, but in many countries like Turkey, Egypt, we're seeing lawyers taken out because of the clients they're representing.
I mean, I think in this debate, one of the frustrations is trying to communicate with the other side, who have a very strong perspective that about rule of law, access to justice, and find some common ground, like amongst lawyers, about how where people are entitled to legal representation and they're entitled to bring claims, and
but isn't that just the problem with the law? Like, there is no access to justice in defending your reputation if you have no money. Like, this is access for rich people to justice. You have to have £1 million to have any kind of, like, to defend your reputation in this country. And to defend your right to free speech, in my case, is you have to, you know...
Well, it's not free speech, it's expensive speech.
Well, in my case, it absolutely proves, and this is what we are... Tom is sitting in the audience, who's my lovely lawyer here, is, you know, we are discussing...
I noticed he had a hole in his shoes. You've not been paying his bills again.
Well, there might be something. Let's keep that one on the down low. But you know, in my case, is absurd. Is that there is no freedom? You know, we don't have free expression. We have very, very expensive expression.
Yeah, and I think there's something else in this that you're talking about, which is quite important, really, because the theory of contested litigation is that each party has the same sort of resources to bring before the court at equal arms, and therefore have the court do justice. But that just isn't...
It's an absurdity. And I think especially like this idea of like spending 4 million over 15 tweets. I mean, it's just, the law hasn't kept up with, you know, the means of expression which we all have at our fingertips and are using. And, you know, I think anybody in the public eye is defamed, you know, on an hourly basis across any digital platform, aren't they? So how I just don't really understand defamation in this context. All it is a protection for very rich people. And is that what we want? Oh, I like it. Yes, brother. I mean, it just does not seem fit for the society that we are living in and the means of expression that we are all using.
Well, I mean, in my case, it cost us about £70,000 not to even reach the courtroom. The case collapsed before them. The problem we had, in the hearing we're going to have, we're going to ask for an escrow account to be set up for Bogosian to pay money into so he could pay costs if he lost. And we understand from the emails that he didn't expect to win. This was really, again, about making me suffer and making me have those costs. But because we didn't even get to that point, we have no way of recovering our money at the moment. We're waiting on the Solicitors Regulation Authority complaint that's just taking forever to come through before we can take any sort of action. We also have, on top of this, we have the UK Treasury's Office of Financial Sanctions Implementation give Bogosian sanctions relief to sue me for the thing he was sanctioned for, which just was absolutely maddening. I just couldn't understand how that had happened, and this was raised in Parliament by a number of members of Parliament, and no one wanted to give a straight answer. I mean, maybe because Rishi Sunak was the head of the Treasury at the time, but I find it extremely worrying that the UK Treasury is unable to explain how decisions are being made.
Well, I think this is a really interesting point. So, one of the things that I've noticed as a trend, and it may be that yours is an example of this, is that governments use intel and intercepts and all their other assets in order to come to a conclusion about someone like Bogosian. But they only document the public record of information. So your article gets cited, although the iceberg of information is in fact labelled secret or top secret. And so I think that is always going to lead you down the path of exposing journalists, isn't it?
Yeah, and if you look at my case, I mean, if you can sue someone for linking to tweets of major media organisations for the content of those articles, pretty much anyone can be sued by anyone. I mean, these articles, the content of the articles weren't really being challenged. It's really the fact that I had been tweeting them that was the issue, and that I had libelled them. CNN didn't get sued, Spiegel didn't get sued, Bellingcat didn't get sued. I got sued for tweeting those articles. It just seems utterly bizarre that we can have a legal system in the UK that allows that to happen in the first place. It's absolutely madness. And it really opens up anyone to being sued for anything they post on social media, even if it's not something they've written themselves.
And Prigozhin, had he gone forward with this case as well, you know, he would have got to do discovery on all of your documents and messages and all. I mean, it's just, you know, just think about that, like and that would have been completely allowed under the law. And to go back to the stresses of my case is that, and this is where I was staring at Tom. Tom held my hand through the discovery process, which I found absolutely debilitating. This handing over the keys to all of my accounts. No idea. You've got, you know, 4 years worth of messages, whatever. Who knows, you know, what was going to be back then, which could then be weaponized and used against me. And access to, you know, sort of so much information that have gathered along the way. I mean, that was sort of an extraordinary thing that if we're going to countenance that happening to our journalists by the people that they're investigating, they get to do that. I mean, this is not a foundation for any kind of society that values the ability to, you know, what journalism is supposed to be about, trying to hold power to account.
Yeah, and the sort of, you know, the theory that we're all supposed to know about issues of moment and make up our mind, and you know, there's a free flow and democratic understanding of information. But that leads me to another question, which is about lawfare. So, I mean, you talk about the challenges of disclosure, but you know, one of the trends I'm seeing is subject matter requests, subject access requests being filed before the lawsuit. And that seems to be to gather evidence of defamation from internal discussions. Now, clearly there's a journalistic exemption, and it also applies to NGOs, but it's not very rigorously pushed back on very often. And, you know, there are third parties around that they can go and have a go at. Is that something you're seeing as a problem? Is that something that either of you or any of you are seeing?
I mean, it's a massive problem in news organisations, and I think probably some of the media lawyers here have more experience of that than I specifically had. I have also found it quite a useful investigative tool, I have to say.
So you weaponised it against them? Yeah, okay.
Subject access requests are being used more against media organisations. A slightly more worrying trend.
Well, can we just unpack that a little? Yeah. Come back to your worrying trend, but, you know, there's an exemption for media organisations, isn't there? So is that a complete answer, or do you still have to go through the material and review it?
It's again all tied in with the public interest and being able to evidence the public interest. So I'd say on the whole, media organisations are pushing back quite hard on subject access requests. But you're right, there are other avenues where that exemption doesn't apply. Under the GDPR, there's the right to be forgotten, the right to erasure, was the worrying trend I was mentioning, because increasingly it's being used to try and get newspaper archives anonymized when they reach a certain age. So I was convicted of fraud 9 years ago. I shouldn't have this turning up on my Google account. And it used to be that those were sent to Google, but that those are now being sent to news organizations themselves, who are, you know, with increasing frequency having to fight off attempts to basically wipe the slate clean after a number of years. So yeah, I think genuinely speaking, data laws are being weaponized.
Yeah, I think this is right. And I mean, because one of the things I'm interested in is that you have to explain to the journalists, don't you, that I'm going to have to go through all your sensitive material to make sure that it falls within the exemption. It's not an automatic blanket. You've actually got to do the work. So even though you might not hand over much, it's quite intrusive, quite time concerning. And I think, you know, that also is a form of SLAPP, because you're trying to denude resource, aren't you, I think?
Yeah, absolutely. I mean, you can treat every subject access request like a mini disclosure exercise.
Yeah.
And I mean, just to go back to Carole's point, because until you've been through litigation, you don't quite realize how invasive disclosure is. And, you know, it's every WhatsApp message, every email you sent, whether or not you were joking, is being sent to the other side. You're then being cross-examined for, was it 4 days, about every single remark you made, whether that showed that you've got a hatchet to bury.
And I just get, you know, the thing I always thought about, there's that is it Cardinal Richelieu? There's that famous quote about, give me, 7 lines written in any man's hand and I will find a reason to hang them. And it was like, well, actually he had 40,000 documents. And if you can't find something in there to like use against somebody, then really the lawyers aren't doing their job.
And sorry, did you get to disclosure in your case?
No, we actually ended up being a bit disappointed by the case ending so early because...
well, apart from the fact you couldn't get your costs back.
Yeah, I mean, we had quite a lot to say about Prigozhin, quite a lot of information that we would be more than happy to share with the court and make public. So we were kind of looking forward to this being an exercise where we could kind of even make the case even stronger for sanctions against him, which was kind of against what he was doing. But of course, I'm glad that we didn't have to have the stress, the expense that would have been involved with that. But we were ready to really fight this hard had it come to that. But I really would have preferred it didn't involve the invasion of Ukraine by Russia to stop the case from proceeding.
Yeah, I think we can all agree on that. I wanted to move on, if I may, to the issue of lawfare more broadly. We're talking about SLAPPs, and you know, here we're at the SLAPP conference. But it seems to me that there's also this trend where lawfare is being pressed into service. So historically, we've used, or people have used, libel claims, privacy claims to essentially stop journalistic output or curtail it. And it seems now that journalists are also being targeted with other laws. So you look at Maria Ressa, where you know she's being done for tax. You look in Azerbaijan and you see them using criminal offences against journalists who are critical. Is this something that you think is a wider problem, and is it going to come here?
I hope not. I mean, we've because Bellingcat operates in a lot of different areas. We have staff all across the world. We have had problems in some states where our journalists have been targeted because of the research they've done on various topics. It is worrying, but you kind of have to be aware of that in the work that you're doing and be ready to respond to that in the best way that you can, which isn't always a pleasant experience, but really a lot of it is just preparation and understanding, you know, the environment you're operating.
I think it is. I mean, I think the thing is it's by any means necessary is what these claimants are doing. And I don't know. I saw Jill Phillips here. Maybe she hasn't come into the room. She had. I mean, we had in the catalogue of things which happened before Aaron Bance took a civil suit against me. He did report me to the police. And we did have a stressful meeting with Jill at which we discussed what I would do if the police raided my house at 6 o'clock in the morning, which is what they would be likely to do, and what my procedure should be at that point. And that feels pretty real and very uncomfortable and baseless. It was, you know, these were baseless allegations, but he was making them to a police force, and as Jill said, is that we can defend you from a civil suit, or not, as it turned out, perhaps with The Guardian. But it was in terms of like when things are, it's the state, then there really is nothing that can be done. You know, essentially very vulnerable, and so I think that is a real concern.
I mean, I don't know whether, in the absence of Caroline Muscat from Malta, whether there's any contributions from the audience about this wider trend of lawfare that we're seeing. Is anyone experiencing that? Yeah, just take a contribution from over here. Any others? And some up the back.
Hi, Juliet Garside. I'm Deputy Business Editor at The Guardian, and I led our reporting on big leaks like the Panama Papers and, in fact, Daphne's assassination. And, you know, we've done quite a lot of work over the years looking at the way law firms were marketing themselves to try and attract this kind of work. That's one point I would make. You know, in particular firms like Schillings, Mishcon de Reya, who, you know, you go to their website and you see we've got a Russian language hotline. So we're not talking about the cab rank principle. We're talking about a law firm that sets out to seek this kind of business. You know, Mishcon de Reya has a partner who essentially launched a case, looked for clients, and then took a case to the European Court of Justice to apply privacy principles, to have every single company registry in the EU remove information about who the beneficial owners are of companies, and many of those, the UK hasn't had to do it because that's like the one benefit I would cite from Brexit. But
I'm glad you've identified it.
I found one. So I would call that a form of marketing, as well as quite a large, you know, action on behalf of clients. And one other thing is we've just sorry if I say very briefly, we've just published a series on based on leaks out of Cyprus. Where we looked at information that had leaked from an offshore services firm acting for Abramovich. And we were able to tell stories recently about financial fair play at Chelsea and potential breaches of the rules and third-party ownership of footballers that sports journalists have been trying to tell for 2 decades about Abramovich, and it took sanctions for us to be able to do that. Such were the threats. You know, we were trying to tell these stories last year. We had a legal letter saying that we would be in trouble if we suggested that he benefited from or supported Putin, and therefore was a candidate for sanctions. And within a month, he'd been sanctioned on those grounds. So, you know, if in terms of kind of suppressed stories, we're talking about 2 decades worth at Chelsea.
Yeah, thank you. There was somebody at the back. One of the things I'm interested in is we're looking at this very domestically, and one of the reasons I wanted Caroline here is because of the countries where we have to go to investigate, to report, and sometimes their rule of law is not only expensive, but it's not robust. It is corruptible. So your contribution, please.
Yes, you were asking about other ways of coming after journalists, and law firms are involved in coming after journalists in a sort of 360 fashion. I've had surveillance detail on me for months and years at a time. I've had hacking. I've had major black PR campaigns involving numerous websites set up to discredit me. I'm not the only journalist who's experienced that. And what's particularly disappointing is that, you know, we've seen that being funded via law firms. In the case of Joe Low, who was funding a Malaysian state money into these campaigns against me on the streets of London, this money was going via Cobra and Kim in New York and then Schillings here. Into the PR agencies concerned and so forth. Now, obviously indirectly, but they were linked into this. They were linked into the money trail. And
what do you think is the resolution to that? Is it tighter regulation of English law firms, or is it something more?
Well, I think, you know, again, the SRA, who were here earlier, should be really looking at, you know, this diversification of law firms. As the previous questioner pointed out, you know, they're marketing themselves not just as law firms, but as, you know, 360 service providers for oligarchs trying to operate here. They sort out their...
Do you think that Schillings have solved this problem by splitting into a PR firm to do the non-professionally regulated stuff and then a law firm to do the professionally regulated? Is that a clever move by them? Are we going to see Mishcons doing that next?
Well, I mean, certainly they're being more honest about what they're up to, aren't they? But I think there's an inbuilt conflict in having a company that does two such conflicting activities.
I'll take one more contribution if there's one down here, I think. Oh, sorry, one up the back. Maybe easier to do the one at the back. Sorry about that. I'll get you later.
My question is for Rupert. So you mentioned the case of 15 tweets that you managed to get down to the bargain price of 2 million to get to trial. What that overlooks, however, is that you spent time which correlates to obviously money and fees in arguing that. So do you see potentially a greater role for better case management from courts and specifically judges around costs? Or do you think they're performing as they should within their parameters?
I mean, it's the difficulty is I think reputation management has been carried up. We as the London legal market sell our legal services all around the world for running very, very robust commercial litigation for the biggest companies. They like choosing England as a jurisdiction. And that's all very well when it's Coca-Cola suing a franchisee or two enormous commodity companies. But it's essentially the same system that is running that litigation, is running a defamation claim over a few tweets. And I mean, our judges are on the whole, I think, very, very good. But our court system is under, just like every other public service, is under serious cost restraint. And to really control costs requires a lot of activism by the court. And this cost budgeting process was having a stab at that. Like the court will look at what the costs are like overall, give comments about the costs that incurred, and try and cap the costs going forward. But it's rough justice, and going down from 4 million to 2 million, it's no.
Does that really solve the problem? Is really the point? I mean, because whether it's 1 million or 500,000, your ordinary person is not going to, either of these two are not going to be able to afford that. So is that not, at the end of the day, a denial of justice, essentially, because they don't have access to justice in the same way? And, so that's the first question. And the second one would be, if are we making a mistake in looking at this in a sort of purely UK format? SLAPPs are happening all over the world in some less savoury jurisdictions. So is there not part of the story to be told about what happens if you get slapped in India? What happens if you get slapped in Pakistan or Indonesia? Is there not a wider problem here, which we're seeing evidenced on the stage, but it's a broader problem and it gets exponentially worse depending on the country?
Well, taking your second point first, I think absolutely. The more, particularly if we tighten up our laws, we're basically shifting the problem elsewhere. Like if
doing ourselves out of business.
We're doing ourselves out of business, but you're going to find more. If the EU directive is hollowed out, and we do get a robust general anti-SLAPP law, there might be more people suing in the EU, despite the lower costs than in the UK. But America has grappled with that problem when US citizens got sued, and they brought in first of all, the Libel Terrorism Act in New York, and they've now got the federal speech law, which basically protects US residents from if they get ordered to pay a foreign defamation judgment. Unless that claim would succeed in the US citizen can apply for a mirror cost order against the person who's been awarded it. So, we should be thinking about something like that to protect against it. And in terms of, we were talking earlier about foreign intervention in the jurisdiction. And Claire Castle-Brown, who was speaking earlier, very much the Malaysian state was intricately involved in her case, and the Prime Minister and various cyber troopers were almost gloating about every case management decision that it didn't go 100% Claire's way. So yeah, I think we do need to be protecting more generally about the risk of SLAPPs internationally.
And sorry, we had a contribution over here.
My name is Vanessa Warwick, and I'm a property industry commentator. And I think I have the claim to fame facing the biggest ever defamation damages brought in the history of the UK courts.
Congratulations.
I know. On the topic of this this panel debate, I'd really just, first of all, like to thank the organisers for organising such an important event. And I'd also like to thank Index on Censorship and the Free Speech Union, because without them, quite frankly, I probably wouldn't still be here today. Sorry. Prior to serving me, my claimant undertook an extreme harassment and defamation case against me. One of the things that he did was he put an advert for me as a sex worker on Gumtree with my name, picture and phone number, which resulted in men seeking sexual services from me and phone abuse. The police did take some action and found that the digital trail led to his home address, but the CPS refused to prosecute. There were also numerous vile websites put up about me. My claimant, I only got one letter before being served. Pre-action protocols were not exhausted. And one point I would like to make is it's not just the claimant having deep pockets to instigate the litigation, it's him also having the ability to control the narrative about everything that's going on online. He has made numerous defamatory, harassing and misogynist videos about me. I can't do anything to combat that. My legal bills are already something like 130,000. And I can't sue him for defamation because I don't have the money to sue him for defamation. The police won't do anything. And the impact that these cases have on people is, as Carole said, it's absolutely all just takes over your entire life.
All-consuming. Thank you very much for that contribution. Carole, you were talking earlier about the all-consuming nature of this and, the harassment that went with it and the narrative. Do you have any sort of lessons that you would share coming out of that, other than come off X?
Other than what?
Twitter.
I mean, I think what you're saying really resonates very strongly with me. And during my actual trial, I was very angry about the fact that the entire machinery of the British state was a party in facilitating what I considered an act of abuse and harassment. And you can argue about that all you like, but it was how I experienced what was going on. I think it comes back to it. I feel that, So to Susan and to the rest who've organised this conference and who've done so much to raise this as an issue in silencing and suppressing free speech and journalism in this country has been vital. But and what you are doing is amazing, and you're focusing on the detail of these laws and what needs to be done, and that is what's needed. But I do think, look at the bigger picture. This is a law for rich men. It is a law for rich men, and I think that you've got to just like who is using this law to take what cases. And I would just like to look at those numbers, because it is not available to any of us, I would suggest, in the room. It's not available to people who are having their being defamed on a daily basis across these digital platforms. There is nothing we can do about that. And so I really strongly feel that we've got to have a more profound look at what these laws are, why we have them, and, you know, why we want to keep them, frankly. I mean, Mark, I actually heard something you once said about how they developed out of, you gave this explanation about it was, they were born out of the
blots on the family escutcheon.
Dueling.
Yes.
It was young men dueling in the, you know, for their honour.
Yeah.
And
it was an alternative dispute
resolution.
resolution.
The laws developed to stop poor young men killing themselves because their honour had been impugned by another young man, and that this is where the common law developed from. Is that really fit for the modern society, would you say? I mean, I just...
Well, we're just killing people in a different way.
Here. And, you know, and I know you have to be very polite about judges, but, I mean, do they have any clue about how digital media works? Because does not come across from what I see around these judgments around the meaning of these 5 words in this individual tweet, and this character mean whatever. And in my specific case, like the lack of understanding about YouTube videos and how that works, and how actually most people only watch the first 5 seconds, and there's stats which can show that, and the idea that they're going to watch the whole thing and take away this entire meaning that's been put out. I mean, you know, and I think, as I actually said in my trial, the idea that a single meaning can be assessed for all time across all of the world by a judge sitting in a London courtroom is kind of absurd. That's not actually how language works.
Yeah, I mean, I think that's absolutely right. And we have seen the cases where, you know, the intention of the writer is also taken into consideration as well. But I think you're right. It is an anomaly, an anachronism, if you like, that you light upon this single true meaning. Is that something that you think is susceptible to reform, Rupert?
Single meaning is a device to try and have a system of like working out what has got to be proved to be true.
But that's actually not how language works, though.
No, it's not. It's not.
So you're saying that you ought to be reformed as well?
Well, no. Putting it, I don't think necessarily having multiple meanings or, you know, reforming that rule is what's going to unlock the problem here. I mean,
what do you think it is then that we're groping towards here?
Well, I mean, to Carole's point that this is a rich man's law, I think when in different areas of the law where you need to allow more access to justice, like employment law, they work out a system where employment disputes are resolved much more cost effectively, much quicker in a tribunal. Because if they didn't, it would bankrupt every business every time somebody left unhappy. You know, in intellectual property law, if you make a vexatious trademark threat, you're at risk of a damages claim being brought against you. So in IP law, there's consequences for making threats which are actually baseless, but, you know, not when it comes to journalism about corruption. It's, you know, trademarks that are better protected. So, you know, there are ways, and there are ways that the law does try and get better access to justice, but we're in a sort of quite sanctified sphere in this.
Isn't this the legal industrial complex, frankly? I mean, I know
the legal.
There's a lot of work, there's a lot of money in this, and it's certainly not in the damages, which, as we know, are about 20 grand a pop, if that.
Yeah.
I mean, the whole thing is just, isn't it a bit of a, just like, it's just not fit for the modern age. Sorry, I'm just repeating myself now. But it keeps a lot of lawyers in work, right?
Well, I mean, I think that's right. I mean, one of the, well, yeah, I mean, you know, I get a bit out of it too, but I've had a tickle. But I do think there's something here about finding a different way. So they did go to ADR, but that never really caught on or worked. Do you have any thoughts as to why? in libel cases? So private resolution of disputes?
Yeah, I mean, with media, like national newspaper disputes, there is normally a cost-effective. There's a regulator. It's not perfect, but you can go to IPSO or one of the other regulators, and you can make a complaint, and it's resolved fairly quickly, and you get the regulator, and that costs nothing, and it is something that.
Well, is that right? Does it really cost nothing? Because if a complaint comes in from a member of the public, then the legal team at the newspaper, at your firm or mine, is going to respond, aren't they? Same like an Ofcom complaint.
So yeah, if it costs nothing to make a complaint in terms of sort of access to justice.
Fee, yeah.
No fee and individuals regularly complain in a personal capacity. But it is something that news organisations take seriously. But that it's not a perfect system, but you're getting a caseworker looking at a complaint about the accuracy and taking a decision. And quite often, no outside lawyers need to be used at all run sort of in-house. And you're getting, something like a outcome. If the journalism's baseless and inaccurate, you get a correction force, and it's a lot cheaper than £4 million in 4 years.
Although if you're a defendant, you don't really have a choice. Eliot, do you see any routes to reform here that are going to have a meaningful impact?
Well, I mean, if you look at my case,
I'm going to open it up a bit.
I was sued for tweets that were seen by about 2,000 people for the links that were clicked by about 50 people, and just to get to the point for my case to collapse cost £70,000. There should be a point in that process where a judge says this should be handled differently, because this was the complaint about articles that had been published, not about what I had said on Twitter. This was not me saying on Twitter, Prigozhin is linked to Wagner and he's a bastard. This is me linking to stuff, and the fact that anyone with enough money can come along and just do that to anyone they want in the UK legal system, cost them a vast amount of money. I can't see how it's sustainable, or anything that anyone in this country would actually want to be part of the system. I mean, my case really is such an extreme example of what's possible with the UK legal system. I mean, if that's, after all of this, after all the debate in Parliament and these laws are passed, if that's still possible to happen, then the response has been a complete failure.
I mean, also, can I just say as well that one person who came after me last year, I discovered, I mean, I shan't name names at this point, but maybe afterwards. But they'd also gone after, I was contacted by a 75-year-old man who tweeted something on Twitter and had a process server, is that what you call them?
Yeah,
who'd
come
come
to the
round to the, and was terrified and had got his, didn't know what to do, etc. And so I just sort of think, it's bad enough being a journalist with that, but actually this is also happening to random members of the public, because Twitter and social media platforms are open access to all, right? And it's free. They're free to be, targeted in this way too.
I mean, Rupert, we've talked a lot around costs and the chilling effect of costs. If there was only one-way cost shifting, would that assist? And do you want to explain what that is?
Yeah, it's so that they've got that in personal injury law, which allows somebody to bring a personal injury claim against their employer, and if they win, they get their damages and they get their costs from the employer. If they lose, they don't have to pay the employer's costs. It's cost of business. People are going to sue you. I mean, I'm a member of various working groups on SLAPPs, and so I do hear quite a lot of the other perspective. And in trying to get reform, what's often said is this SLAPP reform movement is a device of corporate media, powerful media interests who are trying to stop, who don't like any interference with their rights. And I know categorically that isn't true, because we've seen, everyone in this room has been part of this discussion and this debate, and it hasn't come from newsrooms who have experienced their fair share of abusive claims, but that's not what's driving it. So we need a solution that protects, the kind of journalism and debate and discussion that we want in this society, but also, there will always be examples on the other side of a case where people feel much more sympathy for the claimant, and if you can't find it, and that's why it sometimes feels like a bit of an intractable problem, because if you can't find a solution that serves both sides' interests, it's a blocker for reform.
Yeah. David Hooper, you wrote a book recently, Buying Silence, How Oligarchs, Companies and Plutocrats Use the Law to Gag their Critics. An excellent read, thoroughly commend it to you. Available at all good bookshops and on Amazon. But in doing your work, was there anything that sort of struck you about this and when you were writing that book?
Well, one of the things that struck me, not quite answering the question.
Oh, okay.
Not quite answering the question. But
Nothing new there, then.
In the previous session, we were told really that the problem related to solicitors and didn't really relate to barristers. And I had a question really for Eliot, because we know that discrete law were involved, but it struck me looking at the case that the bar, perhaps without naming names, piled in pretty enthusiastically about it when they must have known that what was alleged by the claimant was totally untrue and demonstrably on record. He was sanctioned, indicted, and heavens knows what. Secondly, we had the problem. Secondly, they put forward claims that simply couldn't be substantiated at all. For example, you were accused of damaging his reputation in the food and service and restaurant industry, which is not what one immediately thinks of. I mean, did you feel that the bar was piling in against you as well as solicitors, or?
Yeah, I mean, it seems so blatant to me that, when you read through the complaint, like you were saying, there were claims about me damaging his reputation in all kinds of different ways. I can't think any reasonable person who actually spent the time to look at the case, even just, reading through what he was accusing me of, and then, looked at the guy's Wikipedia page, would say, oh, you've damaged his reputation for the tweets you made. Because, again, this is at a point when he was sanctioned by the EU, US, and UK for those very things. So how are my tweets going to damage his reputation further? So, of course, when you have all these obviously very well-paid legal professionals joining in with the case, I can't believe they have the purest motivations at heart when they're doing that.
Oh, sorry, you've got one over here, and then we'll come back to you.
I didn't mean to interrupt again. I just wanted to say a very specific point in relation to the single meaning rule, but a broader point as well. The broader point is that this discussion, lawyers engaging constructively with these very thorny issues, is exactly what's needed. We need more of. There are all sorts of, I think, really creative ideas around about some of the issues that have been raised. So, for example, on the single meaning rule, which has been discussed, Andrew Scott, a few years back, in his, I think, paper that was put together for the Northern Ireland Assembly when they were considering defamation reform, proposed abolishing the single meaning rule, but then having that in conjunction with a jurisdictional bar for claims on capable meanings that have been retracted and corrected, which I think is a really neat solution. But also what I think it highlights is the fact that where you have legal minds who are really engaging that, there are answers. Now, the reason we've moved away from focusing on defamation reform is because the MOJ has been quite unambiguous that this is not something they can entertain. So that's why there is one of the reasons. And also because, as has been covered before, there can be all sorts of different vehicles, as we've seen for SLAPPs, not just defamation. But the broader point is something that I think is important to emphasize, and I made it before. But, in Europe, elsewhere in Europe, you do have lawyers engaging really constructively on this issue. And so I think it's important that we do encourage that and really try to counter the sort of denialism that sometimes sets in parts of the industry.
How do you overcome the sort of almost willful blindness, particularly, I think, of the bar in this country, but I've also seen it exhibited in American legal professionals when we've been looking at SLAPPs at the IBA Human Rights Institute. It seems to me that this idea that the cab rank principle trumps absolutely everything else, and it seems almost including professional obligations.
Yeah, it's a really interesting question. I think, and I mentioned briefly in the last panel about how in the UK and the USA there is this recognizable anti-SLAPP industry, or rather recognizable SLAPP industry, which I think is different from other parts of Europe. And I think that might be attributable, might be the reason why you're having this difficulty with engagement. But I think we need to move away from this being such a tribal issue. In the US, there was a very powerful lobby, the American Association for Justice, which did provide that sort of block for reform. And we've really seen progress in terms of federal anti-SLAPP law in the US accelerate at the point when the AHA became more constructively engaged in that. So I think, you know, it suits everyone if lawyers from across the spectrum are engaging in this issue.
All right, thank you. There was a contribution over here, I think. Anyone else?
Thank you. Irina Borogan and Andrei Solotov have had an injunction against their publisher for the ebook of their book in Hamburg. And we're seeing in the UK and in Scotland, well, sorry, UK, including Scotland, an increase in the use of injunctions, including at times ex parte injunctions. So you don't know an injunction, an interim injunction has been brought against you. So you haven't even been able to present a defense, but you're then prevented from doing anything. Not anything, but obviously the terms, whether it's communicating online, a book being published, etc., which then also can include contempt threats, which then also can include threats of imprisonment or insane, high fines. And injunctions operate SLAPPs on the outcome, but they operate very differently from SLAPPs because they're very quick. And we always talk about SLAPPs being long, drawn out, intended to suck all of your resource, whereas injunctions are quick, brutal, and opaque. And I know, Rupert has talked about this for a while, but like, is there any other? How do you think we should respond to things like injunctions, like that can still exert the same censorious force but work slightly differently?
It's a good question. I know we've been talking about another case where harassment injunctions have been brought and successfully awarded for companies to stop any criticism online, stop online reviews. And injunctions were a problem that the courts tried to solve 10 years ago with a super injunction spring and being threatened with an injunction, and they shouldn't really be available in defamation. Our principle here is publish and be damned. To the extent claimants are trying to work around that, and there's been a lot of speculation about, like, is that prohibition on granting injunctions in defamation compatible with your Article 8 rights? There's certainly people who are pushing for a situation where it's much easier to get effectively defamation injunctions, whether or not brought in that particular cause of action or under another.
But is that sort of reluctance to issue defamation injunctions where there's going to be a plea of justification put on? Isn't that why we're seeing this slip into other areas? So we saw it sort of start in privacy and then bringing in some IP type claims and then data claims, and now we're seeing it go more broadly. Is that part of the background to this, do you think?
But definitely. Like if you close off one avenue or one avenue is not available, look for other ways. So, yeah, Nick, I think it's a worrying trend looking for injunctions, and the law of privacy has developed in such a way that when it comes to reporting any kind of state investigation arrests, anything pre-charge, the starting point is it's very easy to get an injunction, even if that protects serious wrongdoing from coming to light. They are incredibly expensive, incredibly frightening things to deal with. And once they've been granted on an interim basis, unless you've got real resources, most defendants will give up, kill the story, and sign a consent order, trying to just mitigate damage because it feels like an early determination of what's likely to happen at trial.
I want to open up to a wider discussion about. Well, let's take this question here or comment here.
I just wanted to build on the experiences that you've each had. You've obviously got direct experience each of dealing with SLAPP cases. We've got legislation now that many people probably in this room feel is a great step forward, but slightly imperfect. But how would you? The difficulty seems to be to define a SLAPP. It's a really hard thing to do. It could be GDPR, privacy, injunction, defamation. But in your own words, you've probably thought about this a lot. How would you like to see it defined in law?
I think I'll go to the lawyer for a feel for that one.
What I would say, in Carole's case, the judge, no one really knew what they were talking about. Well, the judge... We were on the record.
And you were saying least of all the judge. Okay, right.
No, the judge said it wasn't a SLAPP because
but we didn't present any evidence.
We didn't put any evidence, and also.
And there is no definition of a SLAPP under English law, right?
And they were saying it's. And I think she said because your truth defence had been dropped because a single meaning had been found, which no one anticipated.
I roll, yeah.
But what I think is interesting about the definition of SLAPP under the Economic Crime Bill is it looks at lawyers' behaviour and it looks at the claimant's behaviour. So are they acting in any way which is out of what you should expect in litigation, causing expense, distress, various feeling harassment? And so what it is if you're a claimant and you're acting for ex-oligarch and they're telling you, write Eliot or Carole the most aggressive letter, I want to terrify them, the claimant lawyer will now have a bit of legislation which they'll have to advise their client on, saying if we're permitted to write whatever letter we like, more or less subject to regulatory obligations, but if we're on the aggressive side, you could fall foul of this SLAPP legislation. And so the legislation recognises that you can have a SLAPP, but the merits of the case, so they've been the case is pursued in an overly aggressive way. It's defined as a SLAPP, but the case is also going to succeed. So all the defendant gets is, the important thing they get is cost protection. So the risk of adverse costs is almost removed. And so in Carole's case, if a SLAPP had been defined in the way the Economic Crime Bill defines it, it's perfectly possible that her case could have been defined as a SLAPP, even if it could succeed.
And there's a whole wealth of evidence which we could have put in on that, but it was very clearly set out to me that the only thing I can do is defend, as the defendant, to defend myself from the claim which is put forward. It wasn't that I couldn't. There was no means for me to prove anything else. It was so there's no point about we didn't even discuss doing it because it was pointless. But had we known the judge was going to come and say, well, it's not a SLAPP, then obviously we would have. But
yeah, but that I think may be identifying a systemic flaw which needs to be addressed in the reform, because it's almost as if SLAPP needs to be an assertive defence, that actually these are inappropriate behaviours, and there's got to be, I think, got to be recognised that the judiciary are still coming to terms with it. And I think Karen Stein was troubled by your case. You can see that as its sort of theme through the judgment, but I don't think she wanted to go so far as to say, oh, and it's a SLAPP. I think she wanted to try and find on more conventional grounds so that she didn't get overturned on appeal on the SLAPP, which I think she'd reckoned without your opponent deciding to appeal. I mean, do you think the appeals come to anything? I mean, in the sense of, are there any lessons we should be learning from that?
Well, the lessons are not good ones from my point of view, in the sense that...
But they're lessons nonetheless.
Well, I mean, it's just another absurdity. If it's absolutely been found lawful that what I said at the time in the circumstances, has been found to be lawful, but yet it can still cost me hundreds of thousands of pounds because a multi-million-pound global media organisation is still hosting that content on a website that I don't control. I mean, is that fair? That to me is an absurdity, which is what the Court of Appeal found. And as I said, I think it might have been, is it John? David, I think it might have been, you came up to me and said you were very cross about those Court of Appeal judges. And you said that in the Chancery Court, is it? The judges actually have to go and be told about how, like, financial commodities and etc. work, whereas these judges sitting in the Court of Appeal, sat and discussed for 5 minutes how digital media works, and came to some entirely erroneous conclusions. But you did also say that, and that I think you might have said their collective age was 250 years, and pontificating on the ins and outs of YouTube.
A takeaway here is to go off to the judicial retreat and train them all up and sensitise them to this.
The thing is about it, we're talking about the information system has changed so completely and radically in the last 15 years. The digital media landscape is nothing like the media and information landscape which these laws were designed to protect. And as I say, is that everybody now has access to broadcast at whatever they like, at whatever time of day. And yet we've got our nice little dueling laws which are here to protect just in case there's a bad word which hits a very rich man. He must have his form of redress in front of the law. And that's what this law is talking about. The rest of you, you're going to be called a paedophile, you're going to be called a witch, you're going to be called a criminal, and that's just like, suck it up. That's just how social media works.
I mean, I think there's something coming out of this which is a theme about almost maintaining a pain diary for evidence of SLAPPs. So, you start to document from very early on when they're coming for you the sort of behaviours that are seeing. So you had information weaponised against you. I think you had something similar. And
but I'd previously been threatened with violence by the man who took the suit against me. I mean, it's like there was chapter and verse I could have put into that court around what I believe are the SLAPP characteristics of this case.
Yeah, I mean, I do think this is one of the more worrying concerns, and I'm conscious that we're, delaying folk from getting a drink now shortly, and I know that you'll be available over a glass of wine and perhaps a little more garrulous and name names. I'm hoping, and I was just going to say, I think that, over the course of the next year, we're hopefully going to see some outcomes from the regulatory authorities in this country. And that, I think, is going to start to spark some action that's going to affect the lawyers more directly. But my concern is that that will just result in displacement. We're going to see people going to the sort of harassing techniques, both on and offline, that we've seen used, and also about gathering information and data, the sort of Cardinal Richelieu point. And those areas seem to me to be the sort of areas where we, for SLAPP reform, need to be looking for the course of the next year. Would you agree with that?
Well, I mean, my big concern is that all this effort is going to go to waste when we have the next election. And currently in Parliament, and there's a good cross-party support for a lot of this work. When my case came up, there was a lot of questions from lots of different members of different parties. I'm just worried with the huge change that it appears to be in the cards at the next election. We'll lose the momentum around this, and then it'll be another few years before that picks up again.
Yeah, I mean, it may be that you'll see some of that move to the Lords. But yeah, I do think there'll be less on the Conservative side to perhaps advocate. That's interesting. Well, look, ladies and gentlemen, unless there's something really pressing and urgent, I'm going to draw this to a conclusion. Say thank you. I promised you a cornucopia. I'm sorry that we didn't get to Malta, but I think you've had your money's worth. Go and get drunk. Thank you.